Good morning, ladies and gentlemen of the jury.
Good morning.
I want to thank you for being as attentive as you've been throughout this process. I know it's been a long few weeks. I believe we are finally coming to the conclusion, but I know it hasn't been easy to be here all this time and to pay attention to particularly some of the drier testimony. At the beginning of this process, when we were selecting the jury, all of you were there with a large number of other people. I do recall someone saying it's hard to imagine circumstances where death would be the appropriate sentence. And ladies and gentlemen, now you know the facts of this case. And what this defendant did to Greg and Maggie and Nick and Megan is unimaginable. It's unimaginable what he put them through on August 28th of 2014. And each and every one of you ended up selected on this jury because you assured us that you would carefully consider the evidence, both in the guilt phase and the penalty phase, and that you would be able to consider if the facts are appropriate, and I submit to you, they are absolutely appropriate here. If they're appropriate, you would be able to render a recommendation of death. Now let's talk a little bit about how this decision works, and some of this was discussed way back a couple weeks ago, but the implications of your decision here. Now, in order for a death sentence, all of you must agree. That means across the board, every question, there has to be a unanimous decision, or this process ends right here and he gets life in prison. Only if all 12 of you agree and recommend death, will the judge have the option of sentencing him to death. All 12 of you must agree. And I submit to you that this defendant would like nothing more than for one of you to go back and refuse to discuss it, refuse to deliberate and say, you know what, I don't want to do this, I'm going to be for life. But I urge you all, if any of you are having problems with this decision, any of you feel that you're having doubts about this decision, and as we'll discuss with the facts, there is no doubt that it's appropriate. But I urge you to discuss it with each other. You seem like a group who have been thoughtful up until this point and who have discussed things, relied upon each other. And we urge you, don't be the juror who ends this process by forcing the judge to give this defendant life. The minimum sentence for these horrific crimes. Now, there are 4 questions that are going to be put to you in each count, and one of them is really 2 questions, so 5 questions, let's say. And I will go through all of those with you in a moment, but one of the questions, and we've talked about this ad nauseum in jury selection, involves aggravators and mitigators, and the mitigating circumstances. That's what we did yesterday, is we heard from a lot of people that the defense called to discuss mitigating circumstances. Things either in this defendant's life or about this defendant that may mitigate in some way whether or not a death sentence is appropriate. So let's talk about the mitigators, and at least the things that are going to be put on paper for you to address. Now, granted, could come from anything. It doesn't necessarily have to be on this piece of paper, as I'm sure the defense will discuss, but I'm at a bit of a disadvantage because I can't talk to you about those in advance. So let's talk about the ones that are put on paper and anything else we may have heard. So the first thing I expect to be on the list is the age of the defendant at the time of the crime, 28 years old. Keeping in mind he is approximately 32 years old now. And I submit to you, 28 years old, I mean, he's in his prime, maybe even past his prime at this point. He's an adult. We are not, and you could basically substitute 28 years old with any age and argue that it's mitigation. 18 years, 70 years, 50 years. 50 years old, he's made it all this way before getting into this situation. But 28 years old is not a justification, it's not an explanation, it's not an excuse. And if it is a mitigating circumstance at all, I submit to you, it carries little weight, or should carry very little weight. And the second thing on the list, Adam Matos loves Tristan more than anything in the world. Keep in mind, they also have to establish these. Now, I say to you, really? Loves Tristan more than anything in the world. Let's look at the evidence. What does the evidence show about that? And you could all also perhaps tack onto that. Some of the testimony said that he was an attentive father. But the evidence shows otherwise. The evidence shows that he does not love Tristan more than anything in the world. He loves himself more than anything in the world. He made these decisions, and they all had negative impacts on Tristan. That is not loving Tristan more than anything in the world. Because let's be clear, this defendant murdered Tristan's mother, a 4-year-old autistic child's mother with whom his mother would have been his whole world. And this defendant took that away from him. And his grandparents. And not only that, the testimony is very clear that this happened while Tristan was in the house. Now, the defendant testified that Tristan was not present to see any of it. But recall that testimony for a moment. He said, oh, Megan went and told him to stay in his room. And I questioned him on that. I confronted him on that. Well, wait a second. You had told us this happened, and you were in a struggle, and then they were in the doorway, and then you chased them. When did that happen, that you were able to see that? And, oh, that's logically what would have happened. That's what Megan would have done. I went back, and he was locked in his room. I submit to you that that testimony is not credible. And it is just as logical, probably more logical, that while this defendant is beating Nicholas Leonard to death, and Megan Brown, knowing that he was going to come back and threatening to kill her, knowing that this situation, that there was blood flying around in her room, she would have gone for her little boy and kept her little boy with him. There is a high likelihood that Tristan was present in the room and had to be there when this defendant killed his mother and his grandfather. But then, more than that, so now Tristan's world's never going to be the same. And what does this defendant do? He leaves him there while he goes and hangs out with the neighbors. He leaves him there while he is going to Walmart. And during the day, too, we have the defendant at Wells Fargo. We have the defendant at Winn-Dixie. All while Tristan is in that house by himself with that awful smell and never going to have a mother again. So I submit to you that the defense has not established that as a mitigating circumstance. That is not there. And to the extent that this defendant may care for his child, that it should be afforded little weight. Now, the third thing, Adam Matos' dedication to Tristan is the only reason he came to Florida and ended up in this situation. Once again, the defense has not established this. This is trying to, it implies that Mr. Matos is the victim here. Tristan may have been one of the reasons he came to Florida. You heard testimony from Mr. Ingram that the defendant was excited about coming to Florida. But he is in this situation. He is here because of his actions. He picked up that hammer and swung it more than 30 times between the two of the victims. He took that gun and fired it because of his actions. It's not because of his dedication to Tristan. That is not the only reason he is in this situation. Next thing is life in prison means life without the possibility of parole. This is a true statement. I'm not sure that we heard testimony about it, but the judge is going to instruct you on that, and we all agree that's the case. Whether it's a mitigating circumstance or not, that is for you, the jury, to decide. But even so, it is a statement about what the minimum penalty is in this situation. And again, the facts of this case do not warrant the minimum penalty. They warrant the most severe penalty that the government can render under the law. Number 5 is Adam Matos was raised by a single mother with a mental disability. Now, some of this was established in terms of the mental disability. That was a little bit unclear. We heard one person testify that she was in a position to help Rose Matos with her finances. But it was interesting that Rose Matos and her family members, her son, none of them said anything about any type of mental disability. But even so, I'm gonna label that for now as background, and I'm gonna discuss background in a group later, because there's a lot of things on here that I would say fall in that category of background. Adam Matos never knew his father. And again, it's up to you, the jury, whether or not this is established, because the testimony was unclear to me. At one point, Rose Matos said that Adam Matos' father did not want to be involved in his life, and they only met each other 3 times. At another point, I think she said Mr. Matos may have only met his uncle from his father's side, but it was not clear to me which was the case. So either way, I would label this as background, and we'll discuss it more in a group later. Adam Matos' mother would leave him alone with his brother for extended periods of time when they were preteen age. Again, this falls into a category of background. Now, in terms of that, it appeared clear from the testimony that this would happen because Adam Matos' mother was trying to provide for them appropriately. She was working, she was doing things to try and create as good a life as was possible for her boys. The next 3 are the love of Adam Matos' brother, the love of Adam Matos' mother, the love of Adam Matos' extended family. Now, are those things out there? Absolutely. Are they mitigating circumstances that should weigh heavily? Absolutely not. Now, consider this. In any situation we could be discussing, if there was nobody there for them, if he had no one in the world and no one cared about him, that could be a mitigating circumstance. If he has all these people who come in and care about him, that could be a mitigating circumstance. But also, and I'll discuss this again with background, but part of this is he had people. He had a support structure. He wasn't alone in the world. He had good people, good role models, and should have known, would have known, did know that these actions are not appropriate. Adam Matos grew up in poverty, experiencing an unstable home with frequent moves. I'm going to label that background, and we'll come back to that. Adam Matos grew up experiencing his mother's frequently changing boyfriends. Well, again, this is background, but in terms of frequently changing boyfriends, there was testimony about a doctor, and I believe the testimony was that there was a doctor who was a boyfriend for about 6 years. But it was unclear to me whether there were other boyfriends, how many others, how frequent. So I'm not sure that as worded there, this has been established. As a child, Adam Matos suffered from extreme asthma, which required emergency room treatment. Okay, again, background information, but this is clearly something that he has gotten over by this point in his life. He's a chain smoker. There's nothing worse for a heavy asthmatic who is still suffering the effects of asthma than to be a heavy chain smoker. Adam Matos' mother took a 2-week vacation to South America, leaving Adam and Peter to fend for themselves when they were 10 and 12 years old. Again, I'm going to label this background. It sounded to me like a specific instance. Adam Matos suffered an extreme beating when he was a young child with plastic blinds and a stick. Was not clear to me from the evidence how extreme. Certainly it's something that was testified to and may have happened. But again, I'm going to label that as background. Adam Matos was a huge support in helping Aunt Nancy Matos through rehabilitation for her substance addiction. There was testimony that he was present. I believe that the testimony was he was 14 years old at this time. It sounded like a family thing where Mr. Matos, Peter, and Rose Matos were all present and were all supportive. There was also, I'll bring it up even though it's not here because it may be addressed, I think Mrs. Jones also indicated that there was some support from the Matoses when she went through something tough. But keep in mind, and I'm going to skip ahead, there's some here, including Adam Matos' courtroom demeanor, that he shows great gratitude and thankfulness, that he's always respectful and polite. All these things, I don't know that they mitigate all that much, because it shows he knows how of behaving like a normal person. He knows the right way to react to people and the wrong way to react to people. This is not a person who cannot help himself. This is not a person who has some sort of head injury or mental defect that doesn't allow him to conform to proper behavior. Quite the opposite. He knows he is capable of it. But he made the decision to brutally murder 4 people. Adam Matos graduated from high school. Again, background, but little weight. Lots of people. The majority of people in this country have graduated from high school, and it's not an explanation as to why they kill 4 people. Adam Matos graduated from disc jockey school by commuting every day from Pennsylvania to New York City, motivated by the desire to financially support his son. I think part of this is out there, and by every day, I think that means more every day that there was classes, because I did not hear testimony that weekends and holidays were included, but yes, it looks like he was taking steps at some point to try and get an education with which he could get a job that he wanted. Now, his motivation, I think there may have been testimony about that from Mr. Ingram. Was not entirely clear to me. But motivated by the desire to financially support his son, again, trying to use Tristan or his relationship with Tristan or his attempt to support Tristan as a mitigator falls terribly flat when this defendant did the things that he did, rocking Tristan's world. Adam Matos endured the uncertainty of whether he was the father of Tristan. I don't recall a lot of testimony on that. I leave it to you to go over that. If you recall it, by all means. Either way, that too was a situation that he kind of placed himself in. And certainly it was resolved long before any of this happened. Adam Matos tried to work to support Tristan and pay rent while in Florida by walking long distances, up to 4 miles, to work as a dishwasher until Ms. Austin helped him buy a bicycle. Lots of things in there. Now, once again, so Ms. Austin just passes by this defendant, and this defendant reminds her of her son, and she just helps him for no other reason than he's there to help. I don't know that mitigates a whole lot. Again, this defendant had a lot of people in his life trying to help him. A lot of people in his life giving him a step up from where he might otherwise have been. A lot of people in his life that he could turn to. And yet, he still brutally, terribly murdered these people. Now, the existence of any other factors in Adam Matos' character, background, or life, or the circumstances of the offense that would mitigate against the imposition of the death penalty. This is kind of the catch-all. If there's anything out there that you feel is mitigation, it's something you can consider. Absolutely. And so I told you I'd discuss background. I have a little bit, but all those things that are background, now listen, everybody comes from somewhere. Everybody has experiences that bring them to the point where they are today. Everybody has had challenges. Everybody has had obstacles to overcome. None of them are the same for any particular person. Now, in this defendant's case, there happens to be another person who has shared many of his his difficulties, many of his obstacles, and that's Peter de Jesus. And Peter de Jesus, married, nice family, military, stable job, stable income. Peter de Jesus isn't going out and killing 4 people. He isn't brutally murdering 4 people. He isn't shooting his 4-year-old child's mother in the face. So again, everybody comes from somewhere. And are these things you should consider? Absolutely consider them. Discuss them. But these are things that do not weigh heavily in this consideration. These are things that do not overcome, don't even come close to overcoming the weight of the aggravators that we are going to discuss. And I would remind you, I've gone through the list, but as I said, anything can be a mitigator, and we won't get to talk to you again. This is our last opportunity to speak with you prior to a decision being rendered. So we won't be able to respond to whatever the defense says. So I ask you, as they make pleas for mercy or attempts to make you feel bad for this defendant.
Improper argument. Approach. May I proceed?
Thank you, Judge. But whatever is said from this point forward, I urge you, ask yourselves, what would Mr. Sarabia have responded to that? What would Mr. Labruzzo or Mr. Lawhorn have responded to that if given the opportunity? And in regards to mercy, if it comes up, I submit to you, there was no mercy shown to Maggie as this defendant beat her with a hammer at least 9 times.
Approach. Overruled. You may continue.
Thank you, Judge. Defendant showed no mercy to Nicholas Leonard as he struck him over and over again with a hammer. He showed no mercy to Gregory Brown as he hunted him down all the way to the master bedroom closet and shot him twice. And no mercy when he shot the mother of his 4-year-old child in the face. Now, it can be tough. It can be tough to see when somebody finally reaps the result of their actions. But remember, it is the defendant who has put us all here. It is the defendant who has put us in this situation to make this decision. This defendant, through his atrocious actions, has forced this decision. Now, I recall in opening, defense counsel said, we're here to determine if God decides when he dies or if the government decides. And I submit to you, it makes it sound as if God is going to be upset if there is a death recommendation. And it's simply not the case. This defendant has put us in this situation. This defendant's actions not only decided that Megan and Nick and Maggie and Greg's life would end on August 28th, but his actions have decided that we would be here today discussing this and making this decision. So don't put that on yourselves. It's the defendant who has led us to be here. And just because it is hard for some people, it is maybe hard for some of you to make that decision and recommend that this defendant deserves death, if you're having trouble with that, it's because you know that's what he deserves, that that's what the facts warrant, that you know that that is the proper outcome here. And I'll give you a counterexample. We worked Mr. Labruzzo terribly hard, and he didn't have an opportunity to go see the Spider-Man movie. So he decides he's going to go to Walmart and he's going to steal a DVD of it. And I get up here and we charge him and I say, Mr. Labruzzo needs to be executed for this. Then you wouldn't feel bad for him at all. You go straight back into that room and you'd say, that's ridiculous. We're not sentencing him to death for that. Now, such is not the case here. Quite the contrary. So now let's walk through the aggravating factors. And this is an analysis that needs to be done for each count. And I'm going to go by names of the victims so that it's clear. Now, aggravating factors, there needs to be an aggravating factor in each count. And I submit to you that there absolutely is. And actually, let's talk about Maggie first. One of the aggravating factors is heinous, that the offense was especially heinous, atrocious, or cruel. And you're going to hear heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. And cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. Now, and it's heinous, atrocious, or cruel. I submit that the defendant may fall into all three of those categories, but only one is necessary. And let's talk about Margaret first. Now, we know that Maggie was killed through blunt force trauma. And let's think about that word blunt. I walk up to Mr. Longhorn and I tell him, "You have a terrible haircut." It's blunt, because it inflicts pain, more pain, than if you were more soft about it. Mr. Longhorn, let's talk about your barber for a minute. The word blunt carries a very connotation of pain. And I urge you all to hold this hammer. I mean, in the world of hammers, it may not be the heaviest, but it's definitely not the lightest. And this defendant, Margaret Brown, just worked an 8-hour shift at Wawa. It's a later shift. She's getting home late. She's arriving. Probably wants to rest. She gets out of her car, and bang, bang, and defense counsel said in their questioning of Dr. Palma, we don't know if the first blow was the kill blow. Oh, but we do. The evidence tells us that. Dr. Palma may not be able to do an examination of the body and tell you the order, but we know exactly that the killing blow is not the first blow, even by the defendant's own statements. Because we know that as this defendant pursues Margaret, as he hunts her down, that she ends up on this back wall. And you can see the blow up of this area here, the handprint. As she's already got her hands on her head to get all that blood on her hands. She's falling against the wall. Anna Cox tells us there is an impact close to that wall because of the spatter that we see over here. Again, bang, and then she's trying to get to safety. She is literally struggling for her life, trying to escape the murderous blows of this defendant. She gets to the door. And the defendant on the stand did not agree that this was Margaret Brown's fingers grasping on for dear life. But I submit to you where they are and the manner that they are left, that is the only reasonable explanation. He said he did that when he was cleaning. That just doesn't make sense. She's trying to hold on, to get to safety, to get away from the repeated blows of that hammer. And this defendant is dragging her. Where is he dragging her? Well, he did kind of tell us that. And the evidence also suggested he is moving her, pulling her as he's striking her, into this east garage area. And we see she struggled with him there too, because we have the pictures of that wall right outside that garage door. And we can see, when it's been enhanced, this handprint right here. What is that from? That is from her trying to keep him from pulling her to her death in that east garage room. I'm going to quote the defendant's own words. He agreed some of those were her handprints. I said, she was struggling with you. And he says, we had a struggle in the dark when it happened. I said, she was trying to stay alive, right? He said, yes. But you had a different intention there, right? Yes. And another part, and you could tell that the defendant didn't realize that we knew this. Because I asked him specifically about Margaret's shoes. You recall I asked a couple of the witnesses. She was recovered. She didn't have any shoes on her. We know she wore shoes to Wawa. We didn't recover any shoes in the house. I said, you had to get rid of Margaret's shoes, right? He said, anything that had blood on it, I didn't want Tristan being exposed to it, so I just threw it away. And I said, so Margaret's shoes, she actually kicked her shoes off while you were trying to tie her feet together, right? And he said, most likely. And you know what that tells us? That as he's getting her back into the east garage, as she, after the 6th or 7th blow to the head with this hammer, that he's trying to bind her. You don't tie somebody up. You don't put a bag over their head if you're not trying to restrain them in some way. If she's already dead, then there's no point in doing that. And tying her shoes together, she's coming in and out of consciousness. She's going to know, she's got a bag over her head, that there's difficulty breathing. She's going to be fearful. She's going to be terrorized. Her hands, she's not going to be able to move. And she's going to be trying to kick off her shoes. And then this defendant, not having any of it, just takes his hammer, bang, finishes it off. And she's not going to move anymore after that. So Margaret, in the last moments of her life, was killed in a heinous manner. So we have, I'm going to spell it wrong. That's an aggravator for Margaret. So now, let's go upstairs. 3 people upstairs. Now, Nick. Again, you don't hit somebody that many times in the head and face if they're already dead. And even by this defendant's admission, he wasn't already dead. But I submit to you, the defendant came at him with a hammer from the get-go, and understand at least 21 blows on his chin, on his chest, all about his head. And understand, 21 blows. Nicholas Leonard, at some point, is just not able to ward off those blows anymore. And this defendant, they just keep coming. He's hoping that the defendant will stop. He's hoping it'll be the last one. I'm only at about 9 now, by the way. And it just doesn't stop. It does not stop. $11, $12, $13, $14. The fight is over. Nicholas Leonard can't resist him anymore. And it just doesn't stop. Blood's flying everywhere. And keep in mind, it's at least 21. And the manner in which Nicholas Leonard's head was bashed in, and he was just mercilessly beaten, that is heinous, atrocious, and cruel. So you end up with as an aggravator for Nick as well. Gregory Brown. And I will concede to you that of all 4 of these, the least heinous may be Gregory Brown. However, it still qualifies. So Greg lived through that night the worst thing any father could live through. Because he knows what's going on. We know he knows what's going on. We know he knows about this defendant's murderous rampage because Greg is trying to get to his weapons to defend himself. To defend himself and his only daughter, his little girl. And he knows as he's there in the closet, trying, under all the stress of if he doesn't get this gun loaded or if he doesn't get whatever weapon he is going for out, if he doesn't do that in a manner where he can protect those people, that there will now be nothing standing between this defendant's murderous rampage and his little girl and his 4-year-old grandson. And then he is struck with the pain in the back. No, and he knows, he's going to know he got shot. He's going to know that pain is there. And as he goes down and this defendant faces him for that final shot, Greg Brown is left with a dying realization that there's nothing left. That there's nothing that's going to stop this defendant from getting to Megan. That he has failed. And that is how Greg dies. And that is heinous, and that is an aggravator for Greg. Now, Megan Brown. Well, Megan Brown's last day alive was full of terror and apprehension and fear inflicted upon her by this defendant. We know that even the night before, this defendant was harassing her and she was upset by it. We heard that from Tanya Carlson. And we know that when she arrived home, this defendant attacked her with a knife, and we could hear her. We have the advantage of an audio tape and hear the strain in her voice, hear the effect that it had upon her, hear that she was terrorized by this. But now, in this phase, you have more. You have her text messages to Jimmy Sigler about what was going on after that. And she said, Jimmy, some serious stuff is going on. My son's dad tried to kill me with a knife, we knew that, and is threatening to come back and finish me off. Now we know he's sending texts. You have the phone records. We know that he smashed the phone by his own admission so that you would not get to read those text messages. But we know from Megan Brown what those text messages said. He's going to come back, threatening to come back and finish me off. This defendant all along was telling her that this was coming. And she was afraid that entire day that this was coming. That's how you end up with Nicholas Leonard being there. And then we go on, and keep in mind if you look at these, that the timestamp is in GMT, which the testimony was it would be 5 hours ahead. So that first one would be about 7:12 in the morning, an hour after this defendant attacked her. But then on, Jimmy Sigler's asking her, "Are you okay? I'd make a police report. I'm going to a funeral, and then I'll get with you afternoon, okay?" He's not even in town, is he? So Megan responds at 11:15 in the morning. "Yes, my son's dad. I came home last night, and he put a knife to my throat, and he told me he was going to effing kill me. I had no choice but to grab the knife and plead. He cut my thumb, and my son woke up. He took off. Cops are looking for him." So Megan was aware that law enforcement was trying to find him. "He keeps threatening me, telling me he's going to come back and finish me off." That's what this defendant, he wasn't coming back to say goodbye. He wasn't coming back to try and make up. He was telling her through the text messages he was coming back to kill her. And she lived with that entire day. In terror and fear, her last text message to Jimmy Sigler is, "Thanks, I just want them to find him. I just want them to find him. I just want it to be over. I want the fear to go away." So this defendant made sure throughout the day that she saw this coming. So then, she's at the house. What happens when this defendant reappears armed with a hammer? Megan's going to know immediately. She knows what he's been telling her. She's going to know immediately what's up. And then, as this defendant is attacking Nicholas Leonard and blood is flying everywhere, there's going to be no doubt in her mind what's coming. She can see this coming. She runs to her father. She runs for protection. And this defendant hunts them down, pursues them, kills her father right in front of her. And then she has to go through that, see that happen, absolutely know that she is next. And that after her, there is nothing between this defendant and her son. And she sees it coming, this defendant, face to face, shoots her in the left eye to make sure that she can see it coming all the way until the last moment. And that is what makes Megan's murder heinous. And so that you see now, there is this aggravator for all 4 murders. And ladies and gentlemen, that's not even the heaviest aggravator. Now, heinous, atrocious, or cruel, and prior capital felonies, I would submit to you these are the heaviest aggravators that the law offers. And this defendant hits them all. The manner in which he killed these people, horrible and a weighty aggravator, but it's not even the worst thing. Because there's the prior capital felonies. And basically the summation of that is that he killed 4 people. So each murder is aggravated by the other 3. And ladies and gentlemen, if there was only one, if we were talking about only 2 murders here, I don't know that there is mitigation. There may be, but it's certainly not what's been presented. I don't know that there is mitigation that outweighs another life. And there are 3 other lives in each one of these murders. Now, in terms of the wording, prior capital felony means prior to today. And in terms of this aggravator, it's absolutely been proven beyond reasonable doubt because you yourselves have already found it beyond reasonable doubt. Here you see the document that memorializes your verdict for each of these counts. And it shows that the defendant, as we stand here today, has been previously convicted of all 4 of these, which means that the other 3 aggravate each one of them. Now, I could go into more technicalities with this. If there had, let's pretend for a moment that Nick had been killed 2 years after the other 3, and that trial had actually occurred first, and he'd already been convicted of it. Even though it happens 2 years after, it still is a prior conviction as long as it happened before today. And that is the case with all of these, and the judge will instruct you on that. Adam Matos has been convicted of 4 counts of murder in the first degree from the events of August 28, 2014. A previous conviction for a capital felony can include multiple capital felony convictions arising from a single incident. So now let's talk about the questionnaire and the weighing process. I'm going to go through the first one is Nicholas Leonard, so I'm going to go through that one with you, but I submit to you the analysis will be the same for each one, or at least you will have to go through the analysis on each one. So, number one, aggravating factors. We, the jury, unanimously find, and you all have to agree to this in order to say yes. And I submit to you, you should all agree to this. And again, the first three questions are really easy. The fourth one is a little bit harder, but the defendant has made it pretty easy for us in this case. The first one, Adam Matos was previously convicted of another capital felony. Yes, again, you guys have already made that decision beyond a reasonable doubt. That one, on all of the victims, that should take no time at all. Two, the first degree murder was especially heinous, atrocious, or cruel. Now keep in mind, if we are on Nicholas Leonard, as this one is, then you're looking at Nicholas Leonard's murder. And as we already looked at Nicholas Leonard's murder, 21 shots with a blunt instrument with that hammer is especially heinous, atrocious, or cruel. So you would mark yes. Now next question, that was the two-part question. If you answer yes to at least one of the aggravating factors listed, then please proceed to section B. If you answered no to every one, then you would not proceed. Now I submit to you, you should answer yes on both of these for each of the counts. If for some reason you do not say yes on both of them, again, you can't get around number one, which is the defendant has previously been convicted of 3 of these. So you will be moving on to number B, sufficiency of the aggravating factors. That's actually spelled wrong. We'll have to bring that up to the judge before we send it back with you.
Thank you for that.
I should say sufficiency of the aggravating factors. Reviewing the aggravating factors that we unanimously found to be proven, we, the jury, unanimously find that the aggravating factors are sufficient to warrant the possible sentence of death. Meaning, they are present and they are such that the death penalty is still on the table. And this is not the final question about that. This is earlier on. So this is not a difficult question. This is an easy yes, and you move on. And you're not instructed on aggravating factors that do not apply, but there are others out there. And again, Mr. Matos committed this offense with the heaviest aggravating factors that the law has out there. Sufficiency of the aggravating Part C. If you answer yes to section B. So again, you have to get yes on both the preceding areas to move on. The jury unanimously find the aggravating factors that were proven beyond a reasonable doubt outweighs the mitigating circumstances that were established. Now we've talked about this a little bit already. This is when you do that balance that was discussed so frequently in jury selection. You take these aggravating factors and you take the mitigation that has been presented, and there's no mathematical analysis, there's no, there's 10 mitigators and only 4 aggravators. You have to weigh them. You, the jury, come up with the level of weight that you deem appropriate. But I submit to you all of the things that have been presented and all the things that there's evidence of for mitigation. Even if we were here on just one homicide, then the aggravating factor, the heinous way in which Margaret was killed, would outweigh the mitigation that's been presented. You add to that even one additional person whose life this defendant cut short, and it's not even a contest. This defendant added 3 additional people. So I submit to you that this should not be a terribly difficult analysis for you. The defendant, through his actions, has made it easy. And the answer, unanimously, should be yes. And then you get to the last question. And the last question is your recommendation. Do you unanimously find that the defendant should be sentenced to death in this case. And this is an analysis in each particular count. In theory, you could say death is to one and not the other, but I submit to you, in this particular case, in these particular counts, there is no reason to do that. And this is the question that may be harder for you. But again, the defendant in this case has made it easy through his actions. He wiped out a family. He wiped out a house full of people. And if you believe his testimony, hours apart from each other. Life in prison without the possibility of parole, that is the minimum sentence. That is the minimum sentence if there was only one first-degree murder here. If Nick was the only one that was killed, life without the possibility of parole would be the minimum. And for the facts that you've all heard from the testimony that has established those facts, from the defendant's own testimony in some situations, this is not a case. This is not a case that the minimum sentence is appropriate. This is a case that warrants the most severe penalty that can be imposed. And it's still far more merciful than what this defendant put any one of those people through. With all of that in mind, with all the actions of this defendant that he chose to do, with the threats to Megan, the warning, the decision that he was going to come back and finish her off, and the brutal manner in which he did it, the heinous manner in which he did it, and the fact that he killed 4 people, we are asking you to recommend the only sentence that is really appropriate based on all those facts, based on these aggravating circumstances, and to recommend that this defendant be given the most severe penalty, the death penalty under the state of Florida. Thank you.
Judge, may we approach?
May?